Daniel Harper had never considered himself an important man. In fact, he preferred it that way. At 42, he lived a quiet, predictable life on the edge of a small rural town where the roads were long, the nights were silent, and people mostly minded their own business. His home wasn't fancy, an old two-story farmhouse built by his grandfather decades ago, but it stood strong against time, surrounded by acres of land that had once been a source of pride for his family. What made the property unusual wasn't the house, it was what lay behind it. A natural spring. It wasn't something Daniel had created or even fully understood as a child. He remembered being warned not to play near it when he was young, as if it were something sacred or fragile. Over time he learned why. The water that came from the ground there was pure, so clean that even local geologists had once called it exceptional. It wasn't just a stream, it was a natural underground source that never dried, even in the harshest summers. 15 years ago, everything changed. A bottled water company had come knocking on his door with engineers, lawyers, and surveys. They had tested the water repeatedly, brought in specialists, and offered Daniel something he never expected: a long-term legal agreement to extract and purchase water from the spring. At first, Daniel hesitated. He wasn't a businessman. He didn't trust corporate people walking around his land with clipboards and expensive boots. But the contract was solid, fair, and carefully structured. Every detail was documented. Ownership remained with him. The spring remained his property. The company was only buying access to a natural resource. So he signed, and for 15 years that decision quietly changed his life. Tankers came and went on a strict schedule. Payments arrived like clockwork. Daniel didn't get rich overnight, but he became stable in a way his grandfather never was. He paid off debts, repaired the old farmhouse, and even helped fund local community projects without ever seeking attention. To him, it was simple: the land provided, and he respected it. But stability has a strange way of attracting attention. It started small. A letter arrived one morning in a clean white envelope, stamped with the logo of a newly formed HOA from the nearby gated community that had expanded closer over the years. Daniel almost ignored it. He had nothing to do with their neighborhood rules, and his property was outside their direct boundary. But the tone of the letter was unusual. It wasn't polite, it wasn't neutral. It was demanding. The HOA claimed that environmental concerns had been raised regarding increased commercial activity near shared community land. They referenced vague bylaws, unclear jurisdiction, and suggested a review of the spring's usage. Daniel read it twice, then placed it on the kitchen table, unimpressed. He had seen corporate paperwork before. This felt different, but not powerful. More like noise. He didn't respond. A week later, another letter arrived, then another. This time the tone had shifted. It was sharper, more authoritative. It accused him of unregulated commercial exploitation and hinted that legal consequences could follow if he refused to cooperate with the HOA board meeting request. That's when Daniel frowned for the first time, because now it wasn't just paperwork, it was pressure. Still, he had the law on his side. At least, that's what he believed. What Daniel didn't yet understand was that someone inside that HOA board had already done their homework. And they were no longer just curious about the spring, they were interested in controlling it. The HOA president, a woman known in the community for her strict rules and controlling nature, had recently been given a report about undeclared commercial activity near the neighborhood boundary. When she saw the numbers attached to the spring's output, something changed in her behavior. What Daniel saw as a quiet piece of land, she saw as opportunity, a resource. A revenue stream that wasn't under HOA control, and in her mind, anything that wasn't controlled was a problem. The next notice was delivered in person. A man in a pressed shirt and HOA badge arrived at Daniel's gate one afternoon while the sun was lowering behind the trees. He didn't step onto the property, he stayed near the fence, holding a clipboard like it gave him authority. "Mr. Harper," he called out, "we need to discuss compliance regarding the spring usage." Daniel walked out slowly, hands in his pockets. "There's nothing to discuss," he replied calmly. The man hesitated, then continued reading from his notes. The HOA has received complaints. There are concerns about environmental impact, traffic from commercial vehicles, and unauthorized industrial activity. Daniel looked past him toward the road where a water tanker had just passed earlier that day. Same route as always, same schedule as always. Those trucks have been coming here for 15 years, Daniel said. Nobody complained before. The man cleared his throat. The board is reviewing historical agreements. Daniel smiled slightly at that. Not because it was funny, but because it was predictable. There's nothing to review, he said. Everything is legal. The man didn't respond. He just nodded like he was already expected to lose the conversation, then left. But as he drove away, Daniel noticed something important. Another car parked further down the road, dark tinted windows, watching. That night, Daniel sat on his porch longer than usual. The wind moved gently through the trees, and the distant sound of water flowing from the spring carried through the silence. Something about the situation didn't feel like a misunderstanding anymore. It felt organized, targeted. The next morning, the final letter arrived. This one was different. It wasn't a warning. It was a legal notice. The HOA, through its attorney, was formally challenging Daniel Harper's right to operate commercial activity involving the spring. They claimed potential violation of community environmental jurisdiction and demanded immediate cessation of water extraction operations pending investigation. Daniel read it once, then again. This time he didn't place it on the table. He kept it in his hand longer than necessary, staring at the signature at the bottom. And for the first time in 15 years, Daniel Harper realized something unsettling. This wasn't about rules. It was about taking something that had never belonged to them, and they had just made it official. The legal notice didn't surprise Daniel Harper the way it should have. It didn't feel like fear, it felt like confirmation. That night, he sat in his small study room with the same letter spread open on the wooden desk. The lamp above him flickered slightly, casting a warm but uneasy glow across decades of paperwork stacked in uneven piles, old land deeds, tax records, inheritance documents, and faded maps that had belonged to his grandfather. If someone wanted to challenge his ownership, Daniel knew exactly what they were really challenging: history. And history in his case was not on the HOA's side. The next morning, he drove into town for the first time in weeks. The courthouse building stood like a memory of old authority, stone walls, tall windows, and the quiet echo of footsteps in hallways where decisions had been made for generations. Daniel requested access to archived land records. The clerk barely looked up. Name? Harper. Daniel Harper. After a short wait, he was handed a thick file box. Dust clung to the edges like it had been untouched for years. Back at a quiet table in the records room, Daniel opened it. And everything began to change. Inside were documents dating back nearly a century, handwritten surveys, original land grants, government-certified ownership transfers. And then, the most important page, a deed. It clearly stated that the Harper family owned the land, including all natural resources, water sources, and underground springs, long before any modern zoning laws, before any municipal expansion, and long before the idea of an HOA even existed. Daniel leaned back slightly. For the first time since the letters began arriving, he felt something solid beneath him again. Not uncertainty. Proof. But he also understood something else. Proof didn't always stop people from trying, because by the time he returned home that evening, another vehicle was already waiting near his property line. This time, it wasn't the HOA representative alone. There were two people. One of them was the HOA president herself. She stood near the gate in a tailored coat, arms crossed, eyes fixed on the land beyond Daniel's house, like she was already measuring it for ownership. Beside her stood a man in a suit, likely her attorney. Daniel stopped his truck slowly and stepped out. The air between them was immediately tense. "So," she said without greeting, "you received our notice." Daniel closed the truck door. "I did." "And?" she asked, raising an eyebrow. "And it doesn't change anything," Daniel replied calmly. The attorney stepped forward slightly. "Mr. Harper, we're trying to resolve this cooperatively. The HOA has concerns about environmental impact and resource allocation." Daniel gave a short laugh. Not mocking, just tired. That spring has been active for 15 years, no environmental issues, no complaints until now. The president's expression tightened. That's because, she said slowly, the situation wasn't properly reviewed. Daniel studied her for a moment. Then he said something simple. It was already reviewed 15 years ago by people who actually had authority. A pause followed. The wind moved through the trees behind him, and somewhere in the distance, water continued to flow steadily from the spring, unchanged, unaffected, uninterested in human arguments. The attorney opened a folder. We are prepared to escalate this legally if necessary. Daniel nodded once. So am I. That was the moment something subtle shifted. Not loudly, not dramatically, but clearly. The HOA president narrowed her eyes slightly as if reassessing him. Because until now they had assumed he was just a landowner resisting pressure, but his calm wasn't ignorance. It was confidence, and that made him harder to push. They left without another word. But as their car disappeared down the road, Daniel noticed something that stayed with him longer than the confrontation itself. The president didn't look frustrated. She looked determined, like someone who had already decided the outcome and was only waiting for the system to catch up. That night, Daniel called the bottled water company for the first time since the dispute began. The call connected after a few rings. A calm corporate voice answered. Mr. Harper, I need legal support, Daniel said directly. There was a brief pause on the other end. Then the voice responded, more serious now. Has the situation escalated? Yes, Daniel replied. HOA is trying to challenge water rights. Another pause, longer this time. Then, we've been expecting this eventually. That line made Daniel sit up slightly. What do you mean? The voice softened, but the tone was firm. Because your spring isn't just a local resource anymore, it's part of a long-term commercial agreement with federal-level documentation. If they challenge your ownership, they're not just challenging you. Daniel frowned. Then who are they challenging? The answer came without hesitation. They're challenging a protected water rights system that has been legally reinforced for over a decade. Silence followed. For the first time, Daniel realized the situation wasn't just local HOA politics. It was bigger, much bigger than he had assumed. After the call ended, Daniel sat in silence again, staring out toward the dark outline of his land. The spring continued to flow as always, steady, ancient, indifferent. But now it no longer felt like just water. It felt like the center of a conflict that had been waiting years to surface. And somewhere out there, the HOA was no longer guessing. They were preparing for war they didn't fully understand. The courtroom was quieter than Daniel Harper expected. Not peaceful, just heavy. The kind of silence that carried weight. Like everyone inside already knew something important was about to break. Wooden benches filled slowly, attorneys, observers, a few local residents, and on one side, the HOA board members sitting stiffly together, their confidence visibly thinner than it had been outside the courtroom. At the center sat Daniel. He didn't look nervous. He just looked prepared. Beside him was the bottled water company's legal team, calm, organized, and carrying thick folders that looked older than the HOA's entire argument. When the judge entered, everyone stood. The case began immediately. The HOA's attorney was first. He spoke about community impact, environmental oversight, and unregulated commercial extraction. He tried to frame Daniel's spring as something that affected the entire neighboring development, suggesting that a shared natural resource should not be controlled by a single private owner. But every sentence felt thinner than the last. Because every time he made a claim, Daniel's legal team quietly placed a document on record. Land deeds, historical ownership records, tax filings, water rights agreements, 15 years of uninterrupted commercial contract history. The judge reviewed them slowly, page by page, expression unchanged, but attentive. Then came Daniel's turn. He didn't speak much at first. He simply allowed his lawyer to present the structure of reality. The property in question, the lawyer said clearly, has been in the Harper family's legal ownership for generations. The natural spring is included explicitly in all historical deeds. Furthermore, there is a legally binding 15-year commercial agreement between Mr. Harper and a licensed bottled water company. He paused. And there has been no prior legal challenge until the formation of the current HOA board. That last sentence lingered in the air longer than expected. The judge looked up. Is that accurate? She asked. Daniel's lawyer nodded. Yes, Your Honor. A quiet shift moved through the courtroom. Now the HOA president leaned forward slightly. For the first time, she didn't look confident. She looked like she was realizing the structure she built her case on was missing its foundation. Still, she tried one last push. "We believe," she said firmly, addressing the court, "that the scale of commercial activity warrants community review and regulatory oversight. The spring impacts our surrounding environment and infrastructure." The judge didn't respond immediately. She simply turned a page, then another. Finally, she spoke. "What you are describing," the judge said calmly, "is not a matter of ownership dispute. It is a matter of private property rights versus attempted administrative overreach." The words landed cleanly. No emotion, just legal clarity. She continued, "There is no evidence that the HOA has jurisdiction over the property in question. There is no legal basis for control or restriction of the spring." A pause, then the final blow. "In fact," she added, "this court finds the HOA's actions to be based on misrepresentation of authority and improper interference with established property rights." Silence. For a moment, nobody moved. Then the judge delivered the ruling. The spring belonged entirely to Daniel Harper. The HOA had no claim, no jurisdiction, no authority over the land or its resources, and their attempts to enforce control were officially invalid. The gavel struck once, sharp, final. The sound didn't echo, it ended something. Outside the courtroom, everything changed quickly. The HOA board members left without speaking to each other. The president walked out last, her expression tight, controlled, but broken in the way people look when they realize power was never real, only assumed. Within days, the consequences spread through the community. Residents who had once supported the HOA began questioning every decision it had ever made. Internal disagreements exploded into public arguments. Financial records were demanded. Meetings turned hostile. Members resigned one after another. The board didn't just lose authority, it collapsed under its own weight, and the lawsuits that followed only made things worse. Daniel, meanwhile, returned home quietly. No celebration, no announcement, just silence and distance from the chaos that had tried to consume his life. One afternoon, a familiar sound returned, the low engine hum of tanker trucks approaching down the long road leading to his property. The bottling company continued operations exactly as before, legal approval intact, schedule unchanged. The spring, untouched by human conflict, kept flowing as it always had, steady, ancient, indifferent to everything that had unfolded around it. Daniel stood near the edge of his land, watching the water move through the channel carved naturally into the earth. 15 years of business, weeks of conflict, one final judgment. And in the end, nothing about the spring had changed. Only the people around it had. As he stood there, he thought about the HOA president for a moment, not with anger, but with understanding. Some people see land and assume control. Others see opportunity and assume ownership. But nature, he realized, doesn't recognize either. It only continues. Behind him, the sound of trucks faded into the distance. And for the first time in a long while, Daniel Harper felt the quiet return, not the silence of tension, but the silence of resolution. The spring kept flowing, and this time no one was coming to take it. If you liked this story, please like, subscribe, and share it with others so they can learn something from it too.